The 5 minutes that decide every personal injury case happen before anyone opens a file. They happen on the intake call, and most firms I know capture none of it. I'm going to show you the 3 things that walk out the door every single time you do not record that call, and why your paralegal's notes are not even close to enough. Think about your last intake. The client got on the phone or sat across from you. For 5, maybe 10 minutes, they talked about the worst day of their life. And somewhere in there, you told them 3 things that decided whether the case is worth $1 million, $50,000, or nothing at all. Who was at fault, how badly they were hurt, and whether you actually want them as a client. All 3 in 5 minutes. And the record you kept of it is a paralegal half listening, writing 4 bullet points on a legal pad. 3 things you lose every time. 1, liability. The offhand line. The client says, almost as a throwaway in minute 3, that the light was yellow when she entered the intersection. That sentence does not make it into the notepad. 18 months later, in deposition, defense counsel hands her a transcript she does not remember giving, and now you are going to have to explain to your client why her own words are different from the complaint you filed. 2, damages. Your client's own language for her pain is the most credible evidence you will ever have. The way she describes the headaches, the second injury she mentions in passing because she has been living with it, the hobby she gave up, the fight with her husband about who picks up the kids now. None of that survives translation in bullet points. You are throwing away the rawest, most usable damages testimony in the entire case, and you are throwing it away in week 1. 3, client fit. The signals you only catch on a careful listen. The inconsistency in her timeline, the relative in the background coaching her, the expectation that a sprained wrist is a 7-figure case, the tone in minute 4 that tells you something does not add up. You hear those things live and your gut registers them, but you have no recording to go back to. So when you're sitting in case selection 3 weeks later, you cannot point to anything specific. You take the case anyway. 6 months in, you remember why you should not have. The paralegal's notepad cannot hold any of this. It was never designed to. It is a tool from an era when intake was a clerical step, not the most important conversation in the matter. Here's what I want you to see. Recording an intake call is not surveillance. It is not extra work. It is the cleanest piece of evidence you will ever collect in the entire case. Gathered in 5 minutes, you are already going to spend on the phone. And once that call exists as audio and as a transcript sitting in the file, every other thing your firm does to that matter gets faster and more accurate. Your chronology has a starting point. Your demand letter has direct quotes. Your case selection has something to point at. The intake stops being a 5-minute drop in the bucket and starts being the foundation the rest of the case stands on. The firms that figure this out are not running harder than you. They are just keeping the evidence that walks in the door. Record every intake. Get consent on tape, keep the audio and the transcript in the file, and stop pretending 4 bullet points is a record. The next case you take will be built on 5 minutes of evidence instead of someone's best guess at what was said. I wrote the longer version of this on my Substack. Link is in the bio. I am James Rabinowitz. Thanks for watching.